So, have you ever wondered, wow, I wish there was a continuation of that random pink haired girl's explanation of IPR? Literally, no one has ever wondered that. Well, you're in luck. I am back, and I'm here to explain not one, but two cases of IPR, specifically in design rights and copyright. Now, this design rights case is quite interesting. It involves Honda and a local brand named Anglo. That. Let me get this out of the way first. This is the first time I've ever seen Honda's full name, and I need all of you to witness it too. It's Honda Giken Kogyo Kabushiki Kaisa. Why is it so long? For why? But I digress. PT Anglo submitted an application for an industrial design in the name of Garuda Motorcycle with the ID 0006493 on October 3rd, 2003. But Honda submitted an application for an industrial design in the name of Motor Scooter in the ID 0000109 on June 19, 2001. So Honda basically said, hey, Nana stealing designs, and so they sued them. In Honda's lawsuit, Anglo did not comply with Article 2, Paragraph 1, 2, and 3 of Law No. 31/2000 by having a motorcycle design that was identical to that of Honda's. There was also a claim from Honda that the design that was sued on February 5, 2003 had already been offered for sale and or marketed before the application was submitted. Ooh, scandalous! After an inspection by the Directorate General of Intellectual Property Rights, based on the letter, it was stated that Garuda Motorcycle is in accordance with Law No. 31/2000. And the decision was read on February 23, 2005, and as follows: it rejected the plaintiff's lawsuit in its entirety, and also ordering the plaintiff to pay court costs of 5,600,000 rupias. That's a lot of money. Now on to the copyright case. For a little backstory, Hendrik Hermanus Jual Ngatong, or Henk Ngatong, was the governor of Jakarta 1964 to 1965 and a talented painter. In 1962, he sketched the Selamat Datang Monument at the instruction of President Sukarno to welcome guests at the 4th Asian Games. And since 2004, Grand Indonesia, the mall, has used the Welcome Monument sketch as part of its official logo. The heirs of Henk Ngatong, the copyright holders of the Welcome Monument sketch, basically said, hey, you can't do that. That's stealing, and you're not providing financial compensation. And so they sued. Well, not yet. In 2019, the heirs attempted to reach an amicable settlement with Grand Indonesia but were unable to reach a resolution. And in June 2020, the heirs officially filed a lawsuit with the Central Jakarta District Court, registered under the case number 35. Oh god, that's too much. I'm just gonna put it on screen later on. I'm not reading all of that. And then in December 2020, the panel of judges at the Jakarta Central Commercial Court issued a verdict. The judge granted the heirs' lawsuit and stated that Grand Indonesia had violated copyright in order for them to pay material compensation of 1 billion rupiahs. Oh my god!